For our fourth video, we're going to turn again to state Supreme Courts and talk about some variations in terms of amici filing at the state Supreme Courts. Now, in looking at Dr. Kane's article, one thing that came to my mind was that she discusses at some length variations in what is known as judicial professionalism, as well as the differences between state judicial selection mechanisms, or the means by which each state selects its state Supreme Court justices. Now, in this area, there exists a wide degree of variation. She juxtaposes in her model states that appoint their state Supreme Court justices versus states that elect their state Supreme Court justices. And that's how she breaks down that dichotomy. But in truth, that's not really a dichotomy. The reason for that is there are primarily four broad groupings that those of us who work in the area of state Supreme Courts identify the methods by which states select their Supreme Court justices. Of those, two of them are what we call contested elections. That is, incumbent Judge A faces off against challenger B. These look very much like congressional elections, mayoral elections, city council elections, elections that you're very familiar with. There are two different types of these contested elections, one being partisan elections. For those of you from Texas, you should be somewhat familiar with these, as Texas is one of four states that uses partisan elections to select and retain their judges. All that partisan elections do that the other type, nonpartisan elections, don't do is candidates in judicial partisan election states list the party identification of the judge on the ballot. This proves to be ultimately a very helpful heuristic clue to voters, as it provides a mechanisms for them to easily identify the candidate who most likely agrees with their ideological proclivities. Nonpartisan electoral states include the same sort of contested election where party A faces off against party B, but those candidates do not appear on the ballot with any form of partisan identification. A third type of judicial selection mechanism is what is known as retention elections. Now, retention elections are unique, and the use of the term election is not entirely accurate. The way in which judges that use states that use retention elections retain their judges is via an up or down vote of the incumbent candidate. That's to say that no one is running against these judges. These judges aren't facing a challenger. These judges are facing what amounts to a public approval contest of the job that they've done as judge. Candidates in these states, depending on the state, it varies with regard to what state has what requirement, usually have to win by above 53% of the popular vote in order to retain their seat. The last type, the type that you're most likely most familiar with, because it is the model which the federal judiciary uses, is that of appointment. At the state level, there exist two different types of appointment mechanisms, unlike the federal level. At the federal level, you should be probably very familiar with the process in which the president puts forth a nominee and the Senate has the authority with advice or consent to approve of the nominee. At the state level, there are two different mechanisms. There's a gubernatorial appointment mechanism, which looks very much like the federal mechanism. But there also exists a legislative selection mechanism in which the legislature puts forth the individuals that will be confirmed. That's only used in two states, South Carolina and Virginia. And so there exists a wide variety of mechanisms by which the states select their judges. There also exists a wide variety of mechanisms by which the states retain their judges. And this variation is chosen for a number of reasons. But usually the one that we put forward the most when it comes to explaining these is because it goes down to the variance of whether we want accountable judges or whether we want independent judges. At the federal level, we prioritize judicial independence. We do that in numerous ways. First off, the selection mechanism does not involve the public explicitly. Second off, judges can't have their salaries reduced while in office. And third, and perhaps the most important protection, is federal judges have life tenure. That is, they're never up for retention. They never have to be reaffirmed or reelected in order to maintain their office. At the state, that's different. At the states, I think there only exist 2 states that have life tenure, 3 with some caveats. But life tenure is exceedingly rare at the state level. So judges on state Supreme Courts are already going to be more accountable and less independent than federal judges. But we think that judges are more accountable if they're in contested elections as opposed to non-contested elections. That is to say that partisanly elected judges and non-partisanly elected judges sit in institutions that are more accountable than retention elections. But all of these different types of selection mechanisms, regardless of why they're put forward, come with a number of unintended consequences. Usually the reason why states choose one particular method over another comes down to a number of political reasons, but also a large debate about whether you want your judges to be more accountable or more independent. But along with both of those sort of taken together, there are numerous other things that we know happen for partisanly elected judges or non-partisanly elected judges or retention election judges or appointment judges. And all of these unintended consequences play out throughout the judiciary. And so that we know large trends based on whether the judges are contested elected, whether they're retention elections, or whether they're appointed. And this allows us to make some significant assumptions and also predict how judges in these systems will actually behave. Turning to amicus filings, this is a different sort of unintended consequence, as opposed to what I do, which is looking at how judges behave because of the selection system. Dr. Kane looks at how other actors, in this case, interest groups, behave dependent upon the election system. And she sees that there are 2 primary things that affect an interest group's proclivity to file a brief in any given case. And those are, 1, if the court is elected in any sense, that is grouping together partisan, nonpartisan, and retention elections all into the same category and comparing them to judges that are appointed, or judicial professionalism, that is, how professionalized is your court system. Now, this measure of judicial professionalism, there's a lot of things that go into that measure, but among them are salary, staff, funding for the judiciary, and so courts that score higher on the judicial professionalism scale tend to be more likely to have amicus briefs submitted to them. And elected courts tend to be more likely to have amicus briefs submitted to them. Now, the designers of these systems, or when states chose to have these systems, I doubt anyone debated or discussed how that would affect interest groups in terms of their submissions of amicus curiae. It wasn't probably on their radar. But we know from this article that it does affect how likely interest groups are to submit a brief. And it's just another in a long line of unintended consequences that come along with the choice of how we choose our judges at the state level.